Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Hey, you guys. How are y'all doing this evening? Hold on, I gotta fix this phone of mine. I had it turned all the way up so I could take a little nap earlier because I just couldn't stay awake any longer. And now I gotta turn it down. There we go. How are y'all doing tonight? Happy Saturday. But then again, we're just one day closer to it being the week, you know, all over again. So there's that. Let's see who's in here. I know it's been rolling for like a minute. Good morning, Gracefully. Oh, yeah. From this morning. I completely forgot about all that crazy stuff. I'm glad that there wasn't too many of y'all that were stuck in here. Not realizing that I switched it. I had put it in there on accident. This is the one that was accidentally marked as AM. That was definitely a mistake. That was definitely a mistake. Yes. I am alive. Yes, everything was fine. I forgot about this. Let me get to now. I'm sorry, you guys. It is a bogus timeline, Mama D. There's just like no way. Especially knowing what we know now. Yeah. It's just insane stuff. Yeah, honestly, the 2 to 4 a.m., the 3 to 4 a.m., that's what they were telling us originally, that it was between 3 and 4 o'clock in the morning, and then everything switched over. And I think it all switched because of Dylan. Basically at 4 a.m., Can I just tell you what happened at 4 a.m.? Okay, well, obviously the noises on the camera tell us something else happened before 4 o'clock in the morning. And it literally is like, as Molly's coming into the area. There's just a lot here. Like, I don't know how they expect us not to ask any questions. Thank you for joining, Deanne Lynn. Welcome, welcome, welcome in. Welcome, Rochelle. Welcome, welcome. Not interested, 00X. Welcome, welcome. Jessa, welcome, welcome. You were watching the game? Oh, I forget football. Forget football times. I should probably start looking at that and seeing what time the games are on and start scheduling around that. I forget about football, guys. I don't watch. I don't watch any sports. I don't watch sports. So I forget about this kind of stuff. I'm sorry. I will pay attention to that from now on. See what time things are. It would make more sense. Yep, we are live. I'm going to end up, I'm going to give y'all these links here in just a few minutes of all these documents that we're about to go over, because it is more than just one. I think there's like 4, all for the defense. I have them in the description box of the live. This is the first one. The actual like trial brief for the defense is the first one that we're going to go over. So I just popped that one in the chat so that if you want to go ahead and get that one up before we get started, you can follow along. And I'm going to drop the rest of the links like we always do as we're going. So if you do want to open them as we go, you feel free to do that too. Or just get the links in and you don't even have to listen to me. Just go ahead and do what you got to do. You turned it up loud. Actually, I really like that little song. Somebody commented that somebody else was using it, and I understand and I appreciate people coming and telling me that. But this is a song called like Domino Beats or Amino something beats. It's called Warzone. It's in the YouTube like backend analytic thing for like people that are like using channels or making channels that need music to use. As long as they get it from YouTube, they can use it however they want to on YouTube. So it's not mine. I just got it from YouTube. Yes, I can't see them. Like I can see like sections of them. I can't even read the whole thing. I can like it. I cannot comment on it, but if I can't read it, I'm not going to like it because I don't know if it's like, I can only read like the first 2 sentences on my dashboard. And even on the computer, like if I wouldn't have gotten the email about Eve's post, I wouldn't be able to read the whole thing. I wouldn't have been able to see the pictures. I don't know. YouTube is doing a lot of update stuff. And it's not okay. Like, it's not working. The updates are causing a lot of issues with views, with getting pushed out to the subscribers. So many channels are having so many issues. I went on Reddit earlier today to look for something not even about that subject and ended up on, like, I don't even know how many Reddit pages of, I don't know how many people having all these problems. Like, YouTube needs to get it together because it's definitely causing some issues. You did mention the other day, chronically, that you thought that you were going to have to switch over. I was getting your comments in the live chats because, like, I could see everything that you were posting, so I don't know what that's all about. But yeah, like, YouTube is freaking out. YouTube really is, like, not. It's got to get its life together. It really does. Hey there, Miller Time. Moonlit Baby, Brooke, Moonvale, Mr. Naysayer, TK, Becca. Why am I here? I know, right? Like, this place is insane. Mama D, Lady Di, Lucas Boyd. Okay, are you guys almost ready to go through these? Kentucky. I've never been through there. I think Johnny Depp's from there, isn't he? I know. Look, that's like the part that's really flipping me out. Because it's like, you can't tell us. You can't tell us that with injuries to the top of his right hand and with the way that his marks were, with the way that he has injuries to his ear, with the way that there's injuries in all these different places, to his wrist, other things, that there wasn't. There's definitely problems here. Yeah, I have like an email chain and all they do is gaslight me the whole time. Because we can get like straight to customer service. They even have like a chat thing in the back. It's kind of difficult to find, but they just like gaslight you like the whole time. Like when my video was demonetized, the video about Austin Dawson, the DoorDash driver that got into a fight with the fraternity member at a University of Idaho, and there's been like a whole thing. The first video that I put out, they demonetized it and restricted it because there was a picture of him in his hospital bed. But it was the exact same picture that News Nation and like all the other stations that finally caught up with the story were using. So when I sent them links and I asked them specifically, okay, so are these videos also restricted because they're using the exact same picture? That's why I used it, because they're big channels. They got away with it. So I used the exact same photo because I am not associated with those channels. They're using some sort of like privacy bullshit to not answer my question. And I'm like, okay, so y'all are just not going to be transparent about the way that y'all are actually doing these things, because I need to know on my end that if I'm using something and then I get told I can't use this, that everybody else by the thousands that I see using it are not allowed to use it either, or else you better put my damn video back where it was. I'm not going to be punished when these bigger channels are getting away with stuff. And literally, like, not even a week and a half later, now I have Law and Crime trying to copyright strike a video. And I'm like, my 20,000 views on that didn't touch your over 2 million. What are you doing? Why are you messing with me? When it comes to the Noons body cam from Noons, from the first responder body cam, the big channels can get away with everything. They really can just get away with everything. And I've tried to get answers, and again, they just gaslight you. They just gaslight the shit out of me. They give me, we can't tell you, or if you want to in order to verify that you have access to this channel that you're sending us a link for, we need you to verify your identity. No, you know what I'm asking you. And I even say that, like, I don't know why y'all are trying to gaslight me. You know what I'm asking you. I'm expecting transparency. YouTube has a lot of problems. I just don't know any other platforms that really like do anything. TikTok is annoying as hell. I don't like Instagram. I'm not really a fan of Facebook. I have what I need for the channel because people asked me to make certain things for the channel, and so I just did it. Because y'all are the channel, and y'all asked me to do the shit, so I did the shit. But when it comes to like another platform to post on, I tried Rumble, and I was putting everything that I had on YouTube on Rumble for like 2 years almost. And nothing was going anywhere. And then I did some research on how to actually do something on Rumble. And you have to pay them, at least at the time that I was looking at it, you have to pay them like $100 a month. It sort of does like the way that X does, where you don't really get pushed out or get seen unless you're a paid member with the stupid blue thingy on your name. Rumble is pretty much like the same way. Like, unless you're paying them, you can put your stuff there. You can use it like storage, but it's not going to go anywhere. No one's going to see anything. You're not going to push it. So I don't know what to do. I'm just stuck here. I'm just trying to figure things out. I'm just so tired of it. YouTube is getting so out of hand. So freaking out of hand. Yeah, they are always on some bullshit. Constantly. And I'm like, really? Why are you touching people? You got these mega bazillion dollar sponsors. You're on cable TV. You're like making money 7 to 8 times over on the same exact stuff that you're posting on YouTube because you're putting it literally everywhere. You're making buku banko. Leave us alone. Like, damn. It's just it's dumb. Hey there, Jackie. I know I don't like Facebook either. I don't have personal social media. Everything social media wise that I have is for this channel. And even before this, it was for my other business. I don't have personal social media. I just don't find a point to it. I just really don't. Okay, we're going to get started. I've blabbed my mouth off enough. Yeah, this is the stuff I'm fighting with. Stupid YouTube, but it's fine. We're just going to keep on doing what we're doing. And that's the wrong thingy right there. It's this one. Yeah, I know they like recently were like, hey, we're going to stop being so stupid basically when it comes to like censorship. And like that didn't work. People did like a test to see how YouTube was going to behave, and it just didn't behave at all. So I don't know what they're going to do. Facebook is a cesspool, but that's always where all of the big crime groups get created and where a lot of information always ends up coming from, which is why it's like, I only made one for the channel because of that. And because that's where like news people, but honestly, Twitter, even though Twitter is even bigger of a cesspool, Twitter is like for news. So even if you don't want to engage with anyone, if you don't want to deal with all of the nasty drama and all the just not really good at all things that shouldn't be on the internet showing up on your feed, but you want like hella fast news on everything, make a fake named account on Twitter and just follow news stations and follow like trending stuff, because you'll get news like this and it'll be like days. I'm telling you, I see stuff on Twitter and it'll be days and days and days before literally a single soul on YouTube starts talking about it. Twitter is so quick, and here I'm still calling it Twitter instead of X, but that's just what it is. It'll always be Twitter. Elon can kiss my butt. It's good for news, but everything else is bullshit. Okay. Okay, we're going to get started now. Again, this is the first one. The other two, and I'm saying the other two, even though there's 3 documents, because one of them is a motion for this Exhibit E to have been sealed a long time ago. So it's just like, I'm going to show you the sealing document and then we're going to read over it. It's what I've mentioned to you guys either earlier today or yesterday. Honestly, probably both times, of a list of like interview transcripts that the defense claims to have that they've submitted to the court on like I said, a list. But it's just weird the way that it's being described, because the verbiage makes it sound as if it's something from the state that the defense has transcripts of and not like original interviews of, but it's like their defense private investigator, that Richard Butanti guy or whoever that was interviewing Bethany and getting information. So I don't know why it's just transcripts if that's the defense's private eye. I don't know why it's like that. So we're going to read that one. And then I found what looks to be like their actual exhibit list, which is, I couldn't find it. I didn't think that I'd find it. It's not listed correctly. It's not labeled like it's a exhibit list. So that's why I didn't know if there was actually one whenever we were going over the 28 pages for the state's exhibit list yesterday. So we have all of that now, and we're just going to go ahead and put all of the defense's stuff together in one, just so we can see everything. So I'm going to go ahead and start reading this one, and then when we move on to the next document, I'll drop that next one in the chat. Okay. And again, this is the defense's trial brief. This is how they were going to do their thing, I guess. Okay. Comes now, Bryan C. Kohberger, by and through his attorneys of record, submits this trial brief in anticipation of the jury trial scheduled to commence on August 11th, 2025 at 8:30 a.m. And that word I can't ever say right, so I'm going to skip right over it. Commencing on July 30th, 2025 at 9 a.m. The court set a date of trial briefing before each side has disclosed its exhibits. Given the 68 terabytes of unorganized discovery, damn straight unorganized, us ourselves seeing it is so discouraging. all of the drops from the ISP, like photos and their reports, all of the reports are out of order. The ones that are in some sort of order, they're not in order by the way that the information was obtained. They're in order by the way that the report was written. And some of these reports for both Moscow and ISP are written months, sometimes even years after the fact. So they're completely out of order. Then we also see like the photos. The photos, they're all wonkatated. You've got Bryan Kohberger's apartment photos thrown in the middle of a file full of King Road photos. There's no actual labels on the pictures themselves. There's no indexes to the photos. Everything is so disorganized. Ann Taylor was not kidding. Like, this is a disgusting mess. And we sort of knew that anyway, because how did Lawrence Mowry like describe it? Something about how he just had a folder and he would just kind of like throw it in there. And I'm like, bro, it take you all of like 10 seconds just to put it in the right spot, put it in their chronological order or ABC order or something. No. So organized discovery, it was even mentioned by the judge how like everything was out of order. And he got mad about how things were labeled and got mad at the defense about the labeling, even though the defense said they were leaving everything the way that it was labeled by the state as to not confuse the record. And somehow, instead of that being the state's fault, the judge went off on the defense for the state's disorganization. This whole thing has been so biased since day one. Absolutely wild. Okay. The defense's inability to have it all reviewed, the ongoing disputes over incomplete expert opinion disclosures, and whatever exhibits the state lists as those it will seek to admit at trial. This trial briefing is submitted in light of that background. The underlying alleged facts are the case are well known to the court and are not reiterated. And then here's the charges. And then it says, on June 26, 2023, the state filed a notice pursuant to Idaho Code 184004A, providing the required notification of the state's intent to seek the death penalty. Jury selection. I think I can make this bigger. I like y'all to be able to actually like see it too. Okay. Jury selection. Jury selection, set to begin on July 30th, 2025, will commence after juror questionnaires have been filled out and provided to counsel. The final juror questionnaire is yet to be determined. Mr. Kohberger has filed a motion seeking to prevent the use of the magic question and other procedures of jury selection. I remember that being discussed, but I can't remember off the top of my head what that was. I'm sure they'll say it. Mr. Kohberger filed a motion on October 16th, 2024, requesting proper Valdir, you know what? It just is what it is. In this capital case, he reiterates his request for individual and sequestered Valdir as it relates to potential juror views on capital punishment as well as case-related information. Evidentiary issues. It is expected that issues surrounding relevance, remoteness, and complete defense will be raised throughout trial. Proof of alibi, alternate perpetrators, and the exclusion of expert opinions due to incomplete expert disclosures will be an issue throughout trial. In the various motions to compel, death penalty motions, suppression motions, and motions in limine filed with the court, many evidentiary issues have been raised. Such evidentiary issues include inflammatory evidence, preventing the introduction of inflammatory evidence such as irrelevant and unfairly prejudicial photographs, testimony, and exhibits is the subject of defendant's motion in limine number 1 regarding inflammatory evidence. Mr. Kohberger contends that his right to a fair trial free from irrelevant, cumulative, and unfairly prejudicial evidence as guaranteed by the state and the federal constitutions prevent the state from introducing evidence that cumulatively highlights gruesome exhibits or elicits overly emotional testimony. Mr. Kohberger heard the court's comments at hearing with optimism, but will, if necessary, be ready to object and follow with a motion to ensure his trial is fair. See, here's the thing with this. We sort of talked about this when it came to the state. I felt like they were adding a whole bunch of unnecessary documents, a whole bunch of unnecessary photographs to what was going to be presented to the jury, while also claiming that they were going to lessen the amount of photographs when it came to like the injuries. And while I understand what their emotional concept would be, this is not about emotion. This is about facts. So if you're going to be trying to tell the facts of a quadruple homicide, you show the injuries. You show every wound. You discuss them at length in order to tell the true story about what happened. You don't need 25 goddamn pictures of somebody's wall with no blood on it, with no hair on it. You don't need a million pictures of a hallway that there's no evidence in. Stop throwing a whole bunch of unnecessary bullshit into the mix. So I agree when it comes to it doesn't need to be so much information to where it feels like this, okay? But this stuff, the gruesomeness needs to be highlighted because that's what this was. So while I understand the argument, I still feel like everything when it comes to their bodies, how they were found, the injuries, while horrible, and it might end up triggering an emotion with the jury that the defense wouldn't have wanted. That's the only way to be honest. So if anything, they should have been fighting to get all the quadruplicate pictures of a blank wall out of the way and having all of the actual photos of the things that matter actually put in there. But that's just my opinion. Excluding experts. Mr. Kohberger seeks to exclude expert testimony that is vague, undisclosed, and improper. Expert testimony and expert disclosures have been the subject of several motions, including A, defendant's motion to compel ICR 16b7 material and for sanctions. B, defendant's motion to extend time to disclose defendant's guilt phase experts. C, defendant's motion in limine regarding, in limine number 2 regarding vague and undisclosed expert testimony. I feel like this desk is like low. Oh, that's my camera. I know Don was like doing school on my desk earlier, and he always like, I want it on 730. He has a setting he's like very specific for, and I feel like I'm like looking down too much, and I don't really like it. It is what it is. Okay, I'll just figure out my neck here in a second. All right. Defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Mr. Kohberger awaits the court's decision on his motion to exclude expert opinions due to incomplete expert disclosures and, depending on the court's decision to exclude late, vague, and undisclosed opinions, these will be ongoing issues throughout the trial. Murder terms. See, this was one of the arguments that I found was dumb. Like, I understand, don't point to him and call him a murderer in court, but this was a murder. Like, what actually happened is a murder. That word needs to be used. Again, don't point at him and call him one, especially since at the point of the trial, there wouldn't have been an actual verdict at that point of the arguments. But to just be like, don't use the word murder and don't use murder weapon as a words. I don't like that. That is like nitpicky stupidity. I said the exact same thing when this first happened. Murder terms. I wonder if YouTube is going to strike this because I'm not using, and I even asked them in that email, I was like, it's crazy. They can say the words murder and, the R word, and I spelled it out. I said, but I have to say schmurder and grape and take away all the actual like severity and seriousness out of the entire thing. It's just so annoying. Okay. Use of the words murder, murderer, murdered, murder weapon, and similar forms of the word schmurder, let's see how stupid that sounds, applied to Bryan Kohberger during the trial was the subject of a motion in limine. Mr. Kohberger understood the court's indication that labeling Mr. Kohberger murderer would be considered argument, and the proper place for argument is in closing argument. Mr. Kohberger is optimistic the case will be tried in accordance with the court's statements and will be ready to object and follow with an appropriate motion to ensure his trial is fair. Now, this one I understood because after the sentencing, I mean, if there's no diagnosis, you shouldn't be using these terms anyway. But what we did find after the sentencing is Santa was asked this very specific question. Is Bryan Kohberger a psychopath? Did you find that he was a psychopath? And he said no, that the testing showed that he wasn't one. So this would have been inappropriate regardless because it wasn't his diagnosis. Psychopath and sociopath terms. Use of the terms psychopath and sociopath is the subject of defendant's motion in limine number 4 regarding using the terms psychopath or sociopath. Mr. Kohberger understands the state has no intention of utilizing such labels. Exactly. Mr. Kohberger is optimistic the case will be tried without the use of such terms. He will be ready to object and follow with an appropriate motion to ensure his trial is fair. I feel like the last sentence of all these are going to be the exact same thing. Okay. Inconclusive data. I'm pretty sure this is about like the DNA samples. Okay. Inconclusive data about the statistical analysis of item 13.1. Yeah, fingernail scrapings. That was Maddie's left hand's fingernail scrapings. Is the subject of defendant's motion in limine number 5 regarding inconclusive data. Mr. Kohberger has now received the state's newest expert disclosure, and based on the work of both the state experts and his own expert, he has been excluded as a source of DNA. Testimony about the lab testing must comport with both experts reviewing the sample, and opining Mr. Kohberger is excluded. Mr. Kohberger understands the state's position to now be that the evidence does in fact exclude Mr. Kohberger as a source of any DNA in sample 13.1. Testimony contrary to that would violate his federal and state constitutional rights to due process, fair trial, and would be false testimony. Yeah, that was an argument for like a while. And what was also crazy is that the state was like, they mentioned this in the grand jury, that it was inconclusive when it came to Kohberger, so they couldn't actually 100% be positive. But instead of doing the further testing the way that the defense did, and how it seems like the state ended up having to do, it's funny because like the defense is basically like pushing them to complete everything. They were just going to leave it that way. But then they had to match the testing that was done by the defense, which is, you know, how it should be, you know, to make sure that things are done matching. My problem, though, is that the defense didn't get the same opportunity when it came to the IgG DNA. Everything about that has been secretive. We've been lied to about it, but we've also been told there wasn't enough for them to run their own IgG to create their own profile from the sample, and that the ones that the feds did create and run through the portals, that it was deleted, that they destroyed it. There wasn't a copy of it anywhere. So while this part, they got to match some stuff up, again, this was something that the state should have never left unanswered, just like there shouldn't be any unanswered male DNA anywhere. It should all have a label. It should all have a name. It's just so stupid. So yeah, I agreed with this because they tried to say they used it as a favor to him in the grand jury. And I'm just like, how the frick is that a favor? You left it open, and people that are going to be hearing inconclusive are going to be like, so there's a chance. That's not a favor to anything. Okay. Number 6, touch or contact DNA. I cannot believe the jury instructions they came up with. This is so stupid. Testimony of Rylene Nowlin, and any testimony referencing the terms touch or contact DNA, or that purports to be an opinion of the means or mechanism for DNA being placed on the sheath by any witness called to testify about DNA, was the subject of defendant's motion in limine number 6 regarding Rylene Nowlin and reference touch or contact DNA. Mr. Kohberger sought to exclude any use of the language touch and contact in the context of the DNA testing of the sheath, and any opinion of how and when the DNA on the sheath was deposited. While the court did not enter an order excluding the language, the court's suggestion that it should not be used to avoid confusion and prejudice to Mr. Kohberger is well taken. His objection will be lodged during trial should the use of the phrase come up. See, I don't understand why they wanted these words. Okay, never mind. I understand why they want touch and contact not to be used, because it gives the false pretense that somebody would have to physically touch something. But touch and contact are not the only 2 words that are being excluded in the grand jury. Not the grand jury, but in the actual like trial jury instructions. I believe trace is even in there. I think so. But this is, again, one of those other things to where, like, if this isn't truly what it is, if it really isn't trace DNA, if it really is something stronger, then why would you need to instruct the jury to ignore those words being used? If it really isn't that, then it shouldn't be used in the first place. And if it really is something as minute as trace DNA, then it definitely needs to be described that way, because that's what it is. I really wish this would have just gone to trial so that we could see everybody's cards out in front of our faces with all this back and forth documents here and there, out of order bullshit. Okay, bushy eyebrows. I don't understand where this came from. I'm still waiting to find where this actually started. Witness identification by bushy eyebrows is the subject of defendant's motion in limine number 7 regarding witness identification by bushy eyebrows. Well, I guess so. Mr. Kohberger sought to bar witness DM from using the words bushy eyebrows or identifying him in that manner. Yeah, because she literally says no. Lawrence Mallory asks, Did you see his eyebrows? She instantly, with no hesitation, no, didn't see his eyes either. So yeah, no, she shouldn't be able to mention it literally whatsoever. Literally at all. Let's see, where is it at? He also sought to keep the state from acting as an identifying witness by attempting to bolster DM's testimony with a photo of Mr. Kohberger taken the morning of November 13th, 2022, and arguing that it is their interpretation that the bushy eyebrows described by DM are consistent with those in the photo. Okay. Should the court allow this testimony and procedure, Mr. Kohberger will object during trial. I mean, the objection literally only needed to be the damn interview. That's the only thing that needed to happen here. Play the interview clip. Okay, discussion over. It's not going to get mentioned ever again. How hard is that? That should be so freaking easy to do. I don't understand the stupidity. All right. IRE 404B evidence. Is this the thingamabobber? Yeah, this is a traffic stop. Okay. And again, you know what? I'll go find it. Because I say this all the time. I have to bring this up constantly. I mean, I don't have to, but, you know, my brain tells me I have to. So let me actually see if I can find where they put the actual, like, the first one right here. Okay, yeah, it is. Okay. So I always mention how the 404B evidence was the traffic stop. And the traffic stop in Latell County really only shows the cop being a dishonest loser, basically. Kohberger is the one being honest in the video. So it really didn't do them any good hiding something that doesn't tell a tale whatsoever that actually fits their narrative, right? The other part about the 404B evidence that really pisses me off is that Judge Hippler came out in an order, and it's one of the other documents, where he put that it was like to prove planning and intent and bullshit, basically. Like he was stalking them as the basic intent of what he put in his order. But that's not the intention of the state. It was never the intention of the state. It literally says right here, in their like literal specifics, okay? The state intends to introduce this evidence for the purpose of proving defendant's identity, vehicle, address, and phone number. That's it. And when we read the rules for 404, it said that if they wanted to use it for preparation, planning, showing stalking, surveillance, or any of those things, it had to be mentioned. It had to be stated, the intentions specifically. None of those things are listed in here. This is only for identification purposes only. So this wasn't going to do anything. They were going to show this in court, and the jury was going to be like, oh, the cop lied. Oh, crap, the defendant was honest. It was going to look bad on them to even be bringing this up. I don't know why they try to put something else on this. Hippler should not have been allowed to rewrite the intentions of this evidence, and the state should have damn well not allowed it. The state should have objected to the way that the order was written and demanded that it be corrected, because that wasn't their intention. How that wasn't corrected, I don't understand, because that's a big deal to me. That's a really big deal to me. Okay. Evidence 404B. 404B evidence has been the subject of a notice, a motion, and a stipulation, including A, state's notice of intent to use IRE 404B evidence, B, defendant's motion in limine regarding regarding unnoticed 404B evidence, and C, sealed stipulated agreement of the parties to not mention the 2014 cell phone incident during trial. Okay. So then what were they going to be asking his sister about? In response to defendant's motion in limine number 8, the state has advised the court and counsel that it intends to comply with the application of the Idaho Rules of Evidence in regard to any proposed IRE 404B. Additionally, in a sealed stipulation, the parties agreed not to mention a 2014 cell phone incident during trial. That incident... You know, I think I don't like the way this hoodie is. And this is like the channel hoodie. And it was fine. I haven't worn it in a while, but I feel like it's just like constantly in my neck. And I've also been trying to figure out if I want to stop using Etsy or not, because the fees with Etsy are like hella dumb. But I haven't tried the spread shop hoodies yet. And it's getting to be cold. It's going to be getting cold soon. So I'm going to have to try it soon. I don't freaking like how this like feels like I'm suffocating. I don't like this whatsoever. Don't buy a jacket. If you were going to buy a hoodie, don't buy a hoodie until I've tested out some other hoodies because this is not comfortable. Okay. That incident involved Mr. Kohberger taking his sister's cellular phone to a kiosk at a mall in exchange for money. His father called police, and the end result of which was a minor theft charge that was later expunged. And according to the last documentary thing that came out, there was somebody claiming that he was the person that Bryan Kohberger called that night. He left some sort of house party he was at, drove over to Kohberger's house, picked him up, and they both went to the mall. So I don't know if he ever got charged with anything, but he knew that it was his sister's phone. Like the guy said in the thing that he knew, if he was being honest anyway, he knew it was Bryan Kohberger's sister's phone, and he knew the intention was because they were out of stuff. And that was the reason why they needed money, because they were out of stuff. And we know he had a substance issue. So it sounds to theme for those kinds of situations. So I don't know, but the guy didn't show his face, of course. So there's that. The state has not indicated 404B evidence other than a traffic stop. Mr. Kohberger will object and follow with an appropriate motion any other act evidence the state seeks to introduce that is unnoticed. Again, I'm just really wondering if it was already decided that the 2014 phone thing wasn't going to happen. What were they going to talk to his sister for? Because that's the only thing I could think of, is that they were going to mention that they were just going to have her like tell the tale because it was her phone. It's interesting. I don't know. I wish I had more information on that. One day, maybe. I don't know. Who knows? Okay, Mr. Kohberger will rely on State versus Whitaker from 2012 for the proposition that although Rule 404B has its genesis in the common law rule that the doing of a criminal act not part of the issue is not admissible as evidence to the doing of the criminal act charged. Yeah, but they use it for escalation. That's what I thought they were going to be doing. I know that with my situation with my ex, they took into consideration stuff that he had done before and then what was going on in our situation as an escalation type issue, because it went from being a dumbass to now you're violent and doing stupid shit, and this is just getting worse progressively. So I understand sort of like what they're saying here about like if it's not part of the crime, then it doesn't really have anything to do with anything. It's not admissible as evidence. But in like jail courts, they use it to show that you've escalated, that you're not learning your lesson. I don't know. It feels like that's a little bit backwards. But then again, he was a minor. So it shouldn't be used because he was a minor at the time. I think he was like 17. I don't even know what year he was born. Wasn't he like 28 when he was arrested? I don't know. I just know he was a minor. He was apparently a minor during the incident with the phone. What year was Kohberger? See, I don't even freaking know, bro. Okay, Bryan. 1994. Well, no, he was 20. He wasn't a minor. He would have been 20 years old in 2014. They've been making it sound as if he was a child. I just never really looked because I knew like his birthday was crazy because it's 11/21, like the November 21st part, but the year I just didn't really pay attention to. Yeah, 94 to 04 and then to 14. He'd have been 20 years old when that happened. I really thought he was a minor. Okay. Well, yeah, they weren't going to use it anyway. Okay. I don't feel like it would have probably done anything regardless. I just thought he was younger. Okay. I believe them a little bit. Okay. I guess I can try to get the file now. I never FOIA'd it because I thought he was a damn kid. That's going to change now. I'm going to see if I can get the documents because I'm curious. Okay. Where are we at? Okay. Well, this is like a long ass sentence. Where the frick does it even start? We already went through this part. Okay, talking about how if it's not part of the situation or has anything to do with part of the issue, then it shouldn't be admissible as evidence. And that is coming from Wigmore Code of Evidence 81. Okay, the rule expands this evidentiary bar beyond evidence of other crimes. The inclusion of the words wrong or acts prohibits evidence of conduct beyond criminal offenses if it is proffered for the purpose of showing a person's character and conforming behavior. In Whitaker, the court held that 404B is not limited to bad acts. And in State versus Pena, 2016, whatever this number is for, unreported. So something unreported? What does that mean in this? See, whenever they say unpublished or unreported, I'm like, why are you citing it? I don't like when those words are on by citations. It makes me feel like it's not a legitimate thing. The same appellate court said that the other act evidence to prove a person's character and conforming behavior falls under 404B. Well, again, in that damn video with the cop, he was the honest one. So I don't know what they were going to try to prove with that. Amazon click activity. Excluding Amazon evidence, purchase history, and Amazon click activity, collectively Amazon evidence, was the subject of defendant's motion in limine number 9 regarding excluding Amazon click activity evidence at trial. The state's methodology in obtaining, using, and producing Amazon evidence has been called into question by Mr. Kohberger, who contends that this evidence should be excluded. To the extent the court allows the evidence, Mr. Kohberger must be able to present expert testimony of David Howell to provide a complete defense. Based on the court's ruling that this evidence will not be excluded at this juncture, Mr. Kohberger will confront the evidence through expert testimony. He will also object to any expert opinion testimony by Mr. Shane Cox or Special Agent Michael Douglas, as the state claims they are lay witnesses and not experts, which is so insane because this is a federal freaking agent. How are you going to label a federal agent a lay witness? That is the farthest. That is the farthest from the truth. The actual farthest from the truth. Okay. Investigative genetic genealogy. Man, I sound like I'm stuffed up. I guess I am stuffed up a little bit. Okay. IgG evidence has been the subject of at least 6 motions, including A, defendant's 3rd motion to compel, B, defendant's 5th motion to compel discovery, C, defendant's 7th motion to compel, D, defendant's motion to suppress regarding genetic information, E, state's motion in limine regarding investigative genetic genealogy, and F, defendant's motion in limine number 11 regarding excluding IgG evidence. The state's methodology in obtaining, using, and producing IgG evidence has been litigated through discovery and motion to compel, and finally through motion to suppress. Mr. Kohberger learned of undisclosed discovery during the suppression hearing and was refused access. As such, Mr. Kohberger contends that IgG evidence should be excluded because he could not fully understand and litigate the issues. At this time, the state has agreed to proceed without use of the IgG evidence and introduce evidence of a generic tip. The fact that the defense even agreed to that should have been not allowed. It's not allowed. Both sides are working towards an agreed upon special jury instruction on the tip evidence to avoid speculation by the jury as to the source and nature of the tip. Why not just be freaking honest? Why can't you just be honest and say, ISP sent it to Othram. Othram did it to this certain point. Then we got it back. We sent it over to the feds and holy moly, they gave us a phone call. Why can't you just be honest? If you have to lie in order to put somebody in prison, what are we doing? Right. Come up with the things that you can sleep with at night. So gross. So gross. Vehicle identification. Exclusion of the state referring to all surveillance footage they intend to offer as suspect vehicle number 1 was the subject of defendant's motion in limine number 12 regarding make and model of suspect vehicle. Mr. Kohberger sought to exclude this evidence pursuant to specific rules of evidence and based on his federal and state constitutional rights. His motion was not directed at the testimony of the state's expert special agent Emil, or is it Imel, something like that, but rather to exclude the state from arguing and other witnesses from saying that all depictions of vehicles were the same vehicle, because it's honestly really difficult to tell. And I will say, one of the videos, I think it's my hair is really getting on my nerves because of where it is in this hoodie. One of the videos where the car was like driving with we could see like its backlights, it's like driving away. I think it was from one of the sunset marks. Those lights look like they belong on a Dodge Charger, because they look like it's a big old rectangle. I mean, I'm not an expert. I'm not going to say that I'm an expert, because I'm not. Okay. But shouldn't everything at least look a little bit the same? I mean, I'm not going to say that there's not a Hyundai Elantra in the damn footage at all. That's dumb. I just don't believe. I just don't believe all of it is the same car. And I don't believe that it's Bryan Kohberger's car. And I definitely don't believe that they've been able to actually prove that. I mean, they didn't even have to, which is the sad part. They didn't even have to try. How did we end up here? I'm so confused. Okay. Mr. Kohberger sought to exclude this evidence pursuant to specific rules of evidence and based on his federal and state constitutional rights. His motion was not directed at the testimony of the state's expert, IML, but rather to exclude the state from arguing and other witnesses from saying that all depictions of vehicles were the same vehicle. Yeah. Based on the court's questioning, Mr. Kohberger must be able to explore with Special Agent Emil the year range he was most comfortable with based on the 1125 Ridge Road footage. That's very important. What he was most comfortable with is important. Which videos allowed identification of makes and models, and which videos caused him to focus on 2014 to 2016 years. The actual evidence provides a less clear trail, and Mr. Kohberger, and exercising his confrontation rights, must be allowed to explore SAML's opinion. Autism spectrum disorder. Mr. Kohberger's autism spectrum disorder, or ASD, along with related issues, was the subject of 3 pending motions. A, defendant's motion in limine number 13 regarding conditions as an aggravator. B, state's motion in limine regarding neuropsychological and psychiatric evidence. And C, defendant's motion to strike death penalty regarding autism. Mr. Kohberger anticipates that the issues related to ASD will arise throughout trial, with continued effort by the defense to explain ASD and provide defenses related to state of mind. Okay, well, I don't really feel like you have to do that unless certain scenarios are being discussed, like the WSU stuff and like how robotic a lot of people think he is, stuff like that. But being autistic doesn't give you a homicidal state of mind. And they've already said he wasn't a psycho. I don't know. The wording there is a bit strange. I don't really like it very much. Okay. Statistical analysis. Statistical analysis and related testimony were the subject of defendant's motion in limine number 14. Statistical analysis. They sure like to repeat themselves. Mr. Kohberger sought an order preventing the state from improperly eliciting statistical testimony. Allowing such testimony would violate his federal and state constitutional rights to due process, fair trial, effective assistance of counsel, and confrontation of witnesses. The state has agreed that they will not elicit testimony attempting to relate the likelihood ratio for the DNA on the sheath to the world population. I mean, honestly, if they could be honest about the way that the profiles were created, then they could do just that. But they want to lie about everything that actually happened, and then there goes their defense out the window, which is so dumb. 911 recording and transcript. I don't know why. This is something that was brought up on Twitter, and I guess I forgot that they had done this. I don't really understand why they would have wanted the 911 call not to be mentioned or not to be played. Because it doesn't, there's nothing about him in it. There's nothing that even like describes him in it. There's nothing. The only thing that it would do is like elicit an emotional response to people that have like heard it for the first time, that don't know the bullshit. Okay. That's about it. So I feel like it should, I mean, regardless, any 911 call should always be played when there's an emergency situation that's now in court, because that's where it all started. That's where the cops got involved. I just don't know why they. I didn't like that they didn't want it played. The recording and transcript of the 911 call to Whitcomb on November 13th, 2022 was the subject of the sealed state's motion in limine regarding the 911 call, relying on exceptions to the hearsay rule and effect on listener emotional response. The state seeks the admission of both the transcript and recording. Oh, I thought they said they wanted it out. That's what the argument was. So they did want it played. Well, the people on Twitter weren't arguing the right argument then, because he wanted it in here. No, he objected to it. See, I need to stop talking before I read the entire sentence. Based on his constitutional rights, Mr. Kohberger objects to the admission of the transcript and the recording. Then I go back to my previous argument. It was dumb. They shouldn't have been arguing that. That's a bad look. For them not to want it in there is a bad look. Alibi. Alibi evidence is the subject of various notices, discovery responses, and motions. On July 24th, 2023, Mr. Kohberger filed his notice of alibi. Pursuant to court order, Mr. Kohberger filed a notice of defendant's supplemental response to state's alibi demand on April 17th, 2024. Previously, Mr. Kohberger's alibi has been the subject of a motion to compel and lots of other things, lots of arguments. More recently, the state filed a motion in limine regarding alibi. Mr. Kohberger has met his statutory obligation of provide the state notice. See that? Okay. Of providing the state notice of corroboration of his partial alibi. Mr. Kohberger stated on the record his concern about the state commenting on his constitutional rights to remain silent. He will make an appropriate motion should these comments be made in front of his jury. I also remember Ann Taylor saying something about there being something additional about his alibi that might be able to come out. I'm so like dumbfounded by this entire case. Alternative perpetrator evidence is the subject of the state's motion in limine regarding alternative perpetrator evidence. Mr. Kohberger anticipates making a proffer of evidence of alternate perpetrator so that evidence can be properly evaluated for relevancy and admissibility under the Idaho rules of evidence. Yeah, that didn't work out very well. Mr. Kohberger notes, as did the court during the hearing, that those investigated do not all meet the factors required to be offered as an alternate perpetrator. That's interesting. That's actually a really big statement to make. Mr. Kohberger's interpretation of the court's comments is that persons investigated by the state may be confronted through cross-examination of law enforcement investigative work. I mean, if there was something in the evidence that had something to do with somebody that was on the stand, they should have the right to be able to ask about it. There shouldn't be anything that's stopped. They should be able to bring up if somebody's DNA was under somebody's fingernails. That should be able to be asked of the person on the stand. And any questions that come from that. If it's a fact, I don't see the problem. But they apparently didn't want that to happen. Demonstrative exhibits, which is the stupid-ass dollhouse. Demonstrative exhibit, the three-dimensional model of the 1122 King Road residence, also known as a dollhouse, was the subject of the state's motion in limine regarding demonstrative exhibits. Mr. Kohberger will continue to object to the use of the dollhouse for distinct reasons arising from discovery issues. Specifically, Mr. Kohberger objects to the use of the three-dimensional model house constructed in an undisclosed way on the grounds that it is irrelevant, prejudicial, cumulative, confusing, and misleading to the jury. Yeah, it's not even to scale, and it should have been for the hundreds of thousands of dollars it probably actually cost to construct. From the pharaoh to the bullshit. It's just so dumb. Family in the courtroom. Family in the courtroom is the subject of the state's motion in limine regarding immediate family members in the courtroom. Mr. Kohberger stipulated in his brief responding to the state's motion in limine that the individuals identified by the state be considered as immediate family of the victims for purposes of being in the courtroom during trial. In his responsive briefing, Mr. Kohberger also asked the court for guidance on proper courtroom decorum and guidance on excluding clothing or anything worn in the gallery that supports the death penalty, and asked that Mr. Kohberger's family members have presence in the courtroom. And what I've always said to this is this: there should be a dress code when it comes to the courthouse, and t-shirts with print on them, like you bought it at Hot Topic, shouldn't be allowed in the courtroom anyway. There should be like church dress code when it comes to a courtroom, in my opinion. And I don't even do the religion thing, but that's the only thing I can think of when it comes to the way people should be dressing. Don't walk in there dressing like you go into the mall. That's rude as hell. So regardless, it should have never even been a thing. It should have, on the courtyard, they can't obviously do anything. But once you're in the room, no, you should have to dress a certain way or go home. Dress like an adult or get the hell out. That's my opinion. The state represented to the court that it had no intention of using its subpoena power to exclude Mr. Kohberger's family. The court asked the state to determine which family members it intends to call, work with the defense, and call the persons out of order so that Mr. Kohberger's family can be in the courtroom. Yeah, see, they've known for a while that his family was going to be called. It was no, last minute thing, and it made his decision about pleading guilty. No. The fact that these damn people make up the most dramatic bullshit is like insane. Death penalty. The death penalty and issues related to the death penalty have been the subject of various motions. Such motions include A, 13 separate death penalty motions with the topics ranging from arbitrariness to utter disregard. B, sealed state's motion in limine regarding improper death penalty comments. C, defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. D, defendant's motion to strike death penalty regarding autism. Most of these motions have been decided while others are pending. Mr. Kohberger anticipates that the issues related to the death penalty will arise throughout trial with continued effort to get the death penalty stricken. And I mentioned it earlier, my stance on that it didn't matter to me who was the actual guilty party of this situation. This was a DP case. This was sadistic. This was a DP situation. But I will also say that just because somebody might have autism doesn't mean that they don't know the difference between right and wrong. So while I understand a lot of people like to use mental health as an excuse, if you can have autism and serve in the military, if you can have autism and have children, if you can have autism and actually like live like a normal human, like most people can, you know right from wrong, and it shouldn't be used as an excuse for you not being punished to the fullest extent because you know right from wrong. You know when you're 3, don't kill things. Sometimes younger. You know, obviously certain spectrums of autism. They're not even going to think about doing those kinds of things because they don't even like have that in them. But for what they're trying to claim that Kohberger has, if he really is the person, it's not an excuse. And it shouldn't have been anything that was ever going to be able to be used as an excuse. And that goes for across the board in my book. Self-authenticating records. Self-authentication of records was the subject of the sealed state's motion in limine regarding self-authentication of records in reliance on IRE 8036 and 8, IRE 9024 and 11, and or IRE 80324. And again, those self-authenticating records was like that 70-something different receipt type things that we saw. That's where we finally got the DoorDash receipt showing it came from Ethan's account. That's where we got the 359 timestamp where it had the geolocation, like the GPS coordinates of where it was apparently dropped off. That's where we saw Marshalls and TJ Maxx and Ross and Target, like all these things then become irrelevant. A lot of stuff be taken out. That's where we got a different time for the TikTok time for Xana. Up until the self-authenticating records, we were told 4:12 a.m. in the PCA. Then the self-authenticating records comes out, and the verbiage in that gives a time of 3:16 in the morning, which is an hour difference and not by the minute. So it's not a time zone difference because the minutes are different too. That's what these were. And again, as they argued them back and forth, they got dwindled down. Little by little, things were coming out and being removed as irrelevant. No evidence. Whatever's attached to it, it's empty, or there's nothing about this specific store on this receipt. This is all useless stuff. That was that stuff. In its motion, the state seeks to admit self-authenticating records. The list of records that the state seeks to admit in this manner is lengthy, and the volume of data is enormous. The big word. Mr. Kohberger has objected to giving the state a free pass for the admissibility of records that are supposedly self-authenticating. After expending extensive time responding to the state's extensive request, request for self-authenticating of authentication of records. The state abandoned nearly half of its requests. See what I mean? Like it all like was just little by little, it's all taken away. Half sounds about right. The court noted the motion was not ready for hearing. Mr. Kohberger will make objections and motions as appropriate. Yeah, that was a whole thing. So much got taken out. Text message and testimony. This is what I really want. This is what I want. One of the main things. Text messages, Dylan on November 13th, 2022, and testimony of Dylan and Bethany regarding their conversation with each other on November 13th, 2022, are the subject of the sealed state's motion in limine regarding text messages and testimony. Mr. Kohberger contends that the way in which the state proposes using the text messages and testimony presents an incomplete picture. Yeah, they were cherry picking what they were giving to us because they only originally gave us like 12 or 13 lines of broken text messages between Dylan and Bethany. And then the defense came out and gave us like a whole bunch more. And then the state had to come in and try to be like, well, we can't hide it anymore. We're going to have to put on here the timestamps prior to the 911 call, proving that these girls were actually awake. We're going to have to be honest a little bit. And they still hit a bunch. There's still a couple of like hours missing. At least when it comes to like super specific stuff. Especially Dylan's especially, for sure. I want to see. Mr. Kohberger has urged the court to view the state's request with consideration of the complete scope of conversations and cellular phone activity and deny the state's motion. AT&T timing advance records. There is something for the AT&T timing advance records that was released, but there's no information on it. It's literally, it's like 2 pages from AT&T, but there's no actual data on it. There's no information on it. I don't know what to call whatever it is, but it's not info. It's not the analysis. It's not the report. Let me go ahead and just show y'all. Let me see if I can find which one. What was it called? Right here. Okay, so this is the only thing they have in here so far. Exhibit 4 in support of objection to state's motion in limine regarding the AT&T timing advance records. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby files under seal Exhibit 4 in support of their objection in the state's motion in limine regarding the AT&T timing advance records. All this is the certificate of authenticity, FBI report from SA Balance, screenshot of records provided to defense, but there's not really like a report. Like this is the authenticity paper. And then there's this. This is what's weird though. Why do they have like extortion and aggravated or overt threats as like the charge for the reason why they're looking this stuff up? I don't know why that's there. I find that very, very odd that they're using this verbiage. Here, I'll go ahead and drop this one in here for you guys. There's that one. But this doesn't give actually like any information. It says like there's files, geofence, timing advance, all from April 2024. But this is not an actual report. It's not. This is from the Salt Lake City office. It was sent to somebody named Jennifer Banks. And again, I don't know why it says extortion. To document additional certified records received from AT&T. AT&T records are enclosed. And it says April 3rd, 2024, Cellular Analysis Survey Team, or CAST, certified Special Agent SA Balance received additional certified records from AT&T. These records will be attached to the 1A section of this serial. And it just shows the screenshot. We don't actually have the records. And they're not like on here either. This is like the order for it actually being sealed, and it hasn't been, like, it's not out here. But that's it. when it comes to the AT&T stuff. That's the only one that we have so far. I just wanted to let y'all guys see that. Okay. In the state's motion in limine regarding AT&T timing advance records, the state seeks to prohibit the defense from making any reference to the absence of AT&T timing advance records or TA reports for Bryan Kohberger. The defense contends that TA reports relating to Mr. Kohberger's cell phone exist at least 7 days of record. Mr. Kohberger has been provided with different explanations by the state regarding the existence of these records throughout the course of his case, including sworn testimony in May of 2024 by Detective Payne. Mr. Kohberger has offered testimony relating to these records based on the explanations presented by the state. The current defense affidavit presented at the in limine hearing is one with more detail and based on the shifting state explanations. Mr. Kohberger has worked with an expert with hands-on experience about TA records, THRU. He was not allowed to testify and explain what he knew about methods officers used in obtaining TA records. Mr. Kohberger understands his ability to question the FBI agent outside the presence of the jury. Yeah, that's the one where he was called a conspiracy theorist while he was waiting on Zoom and could hear everything live and in real life, but couldn't, speak up for himself. Warrants. Okay, let's see how many they're talking about here. Warrants have been the subject of at least 13 suppression motions, ranging on topics from the arrest warrant to the search of Mr. Kohberger's apartment in Pullman, Washington. While the court has already ruled on these suppression motions, Mr. Kohberger anticipates that evidentiary issues related to the various warrants will be raised during trial in the form of inconsistent statements or the impeachment of the state witnesses. Additionally, the state obtained similar information through the grand jury subpoena process. Mr. Kohberger was prevented from receiving copies of the actual grand jury subpoenas and therefore does not know the scope of information obtained. Still to this day, that's crazy. He will make objections during trial based on the rules of evidence. Okay. Investigators in the courtroom. The parties have stipulated and agreed that the defense will have both of their investigators present during the trial, and the state will have its lead investigators from Moscow Police Department, Brett Payne, and Idaho State Police, Gilbertson, present during the trial without limiting their ability to testify. Yeah, but they're not mentioning the facts here that he wasn't going to be part of the Moscow Police Department by the time they got to trial. They literally created a prosecutor's investigator's position to deputize him in order for him to still be able to testify. But they're not going to put all that in here, In compliance with the modification of the court's scheduling order, Mr. Kohberger's proposed exhibit list will be filed and provided to the state by April 28, 2025. While Mr. Kohberger is making every effort to meet his deadline, all discovery has not been reviewed. The 68 terabytes of discovery is unorganized and overwhelming. The court has ordered the exchange of exhibits to be disclosed 1 week apart. The state's expert disclosures are incomplete, and it is expected that subsequent exhibits will be identified and disclosed beyond the court's April 28, 2025 deadline. Witnesses. Expert witnesses. This is the page that I posted in the community tab at hella early this morning, 1 or 2 o'clock in the morning, whatever time it was, because it shows that THRU's name is still on here. So even though people were claiming for months and months and months and months and months that THRU wasn't going to be part of the case, and we did know that he filed basically like a double down in his AT&T information where he was then called a conspiracy theorist, this is still proof that THRU was going to be called at trial. Expert witnesses. Mr. Kohberger had disclosed exceedingly comprehensive expert reports and opinions. The alleged facts are going to be very heavily contested issue by issue. Mr. Kohberger does intend to put on a very extensive defense case. He anticipates calling the following expert witnesses to testify at trial, depending on the state's case in chief during the guilt phase of trial. Ruth E. Ballard, PhD, Stephen J. Becker, Kathleen Bright Birnbaum, David Howell, Matthew Nodal. Nodal is somebody, I didn't know who this was. I wasn't sure who this was. I thought this might have been like a Fed. But now seeing the Matthew name in front of it, we have heard this name before. There's information on their discovery that has this guy's name on it. So we'll get to that here in a minute because we're almost done with this document. Rachel Lawson or I don't know what all this stands for. Some sort of psych stuff. Carol L. Pedden, Kevin H. Pedden. I don't remember these names. Carol and Kevin Pedden. Who is you? Kevin and Carol Pedden? Pedden Digital Forensics. Yeah, Pedden Digital Forensics. It's a company out of Washington, is what it says. Okay. Jennifer J. Horniak Bracamontes, and then there's Cyree. Josiah Roloff, Eileen Ryan, Gary Shuttler, Thomas Slavinsky, Brent Turvey, and Barbara C. Wolf, which we've seen that name 1,000 times. Lay witnesses. Lay witnesses that Mr. Kohberger anticipates calling to testify during the guilt phase of trial will be disclosed by defendant on April 21st, 2025 by filing a witness list under seal in compliance with the court's scheduling order. We've already gone over the witness list for both sides. It's probably been like about a week or so now. So if you guys missed that one, go ahead and scroll back because it should have it like right there on the title. To the extent other witnesses are identified as 68, what? Did I just skip something? To the extent other witnesses are identified as 68 terabytes of discovery are reviewed. Okay. The list will be supplemented. There was actually 3 that the defense put out because there was a second amended. So altogether 3 before they like landed on one before everything went stupid. Penalty phase. Lay witnesses will be disclosed by Mr. Kohberger on May 5th, 2025 by filing a witness list under seal in compliance with the court's scheduling order. Investigation for the mitigation phase of the trial, if the case proceeds that far, is ongoing. The mitigation investigation began immediately upon Mr. Kohberger's arrest, but it has been extremely difficult to get teachers, medical providers, family, friends, neighbors, coworkers, and others to speak with the defense team. Generational records are still being located and gathered. As people and records are located, those will be disclosed and witness list supplemented. And that's the end of this one. That's the end of this one. Okay. So now let me open these. Okay. So this is just the original paper where they were like, we're going to file this under seal, which I don't really quite understand why. Is that what this is? Yeah. I don't really quite understand why. Because of the way that it's worded. Let me pull up the other doc. It just really sounds like it's something that the state had. Just kind of weird. Hold on, let me get this in order here. See how it says transcripts obtained by defense? But then it says Rich Batanti down here, and that's like their investigator. I just don't understand why it's put that way, because I feel like you wouldn't have transcripts, you'd have the real thing. I feel like they would definitely have like the real thing. So I don't know. So what they were, I guess, going to be playing maybe or having ready for trial, I guess. Blaker interviewed Bethany Funk, Hunter Chapin, I guess, or is that Maisie? It'd have to be Hunter or Maisie. And then Ava. I wish we had an initial. So that's 3 from Blaker. Then we have Professor Snyder. And I was like, holy shit, that's crazy that the defense is going to be having Professor Snyder on their witness list when he's the professor that Kohberger was having all of the issues with at WSU. But one thing that was really interesting about Snyder is that in his report, he's telling ISP that they should have never gotten rid of Kohberger, which is sort of confirming the fact he did lose his TA position, even though we haven't seen the documents yet. He's claiming they should have never done that because they didn't have reasoning, and it's going to end up causing some sort of civil lawsuit. That came out of the mouth of the professor that Kohberger was having all of the arguments with. So it really makes you think hard about the situation, because again, the documents that we've been told existed, but we haven't actually got to see with our own eyeballs, is apparently dated on 12/19, the same day that the feds called Moscow. So to sit there and think that the FBI didn't call the school and start digging around, and the school didn't freak out and be like, we just had all kinds of issues with this guy, and we have him on the record all over the place. Now, he was found to do nothing wrong, but if we don't do something now, it's going to make us look bad. We have to look at WSU to save their own asses and shiny up their name real good, the same way that we do with the University of Idaho. So if they're going to produce records that are going to prove what Ann Taylor has stated about how, yeah, there was an investigation about all the bullshit that we've been reading, but he was found to have done nothing wrong because the truth came out for whatever that situation was, and then you don't get fired or lose your position because you were found to do nothing wrong. That's not how that works. So I'm expecting to see documents come out that say the investigation found he didn't do anything wrong, everything went back to normal, and then there was a switch somewhere. And that 12/19 date being the only thing that is being mirrored here, it's got to be the feds and the school just trying to cover their asses. Unless Ann Taylor is lying. Because we don't know anything. We haven't seen anything when it comes to WSU, except for one document that they took a picture of that was dated like sometime in November. That was in his apartment. That's the only paper that we've seen when it comes to all of the WSU stuff. And it's because it's school. The school stuff is held to privacy the same way that like HIPAA stuff is for medical stuff. So unless it gets unsealed and it gets released by the police, I don't think we're going to be able to see it. I really don't. I don't know if WSU would be allowed to release information. I haven't tried to get any information from WSU just because of how the laws are. I feel like it's pointless. But we'll see. We'll see. Because the only thing that I've gotten with Pullman asking about all of that information is just their receipts of sending Brett Payne over the info. And that, like I showed you guys all of the FOIA responses from Pullman, there's several different dates where they sent over Brett Payne batches of information. And he sort of like describes it, but there's not any details. We don't get to see anything. So hopefully we get to see that stuff soon. That'd be interesting to go over it, especially right here. This is an interesting like twist to that whole situation with that professor. Okay. Anastasia Hurt Moran, Flavio Alvarez, and then 2 interviews with this person, Aubrey Scott, Robert Eller, and then an interview with Rich Butanti, which is again the PI for the defense team. There was multiple PIs, but he's the one in all the documents regarding Bethany Funk and the interviews in Nevada where the defense had to go to her. So we have one with him and Ava Wood. Who the frick are these people? Like, obviously I know who the frick Bethany is. Who is Braden Paulo and Braden Jensen? Anybody know who this is? I've never heard these names before. I've never heard these names before. Well, not him. That's the PI. Oh, rich bitch. Is that where you were going? I don't know who these Braden people are. It's got to be 2 different people. I don't know. Why would they need to talk to people in Nevada besides her? And I don't know who, I mean, KF, we've seen those initials. I just don't know. I just don't know. All right. So now we're going to get to what they were going to present. And here is this link right here. That's this document. Okay. Exhibit F to defendant's 6 supplemental response to discovery. The following items have previously been disclosed as exhibits by the defense and are now being disclosed in discovery in abundance of caution. So if this is information coming from the defense, then whose goggles are these? Because if these are some sort of like night goggles or something crazy like that, it'd be really difficult to believe that the defense is the one that's going to present that stuff. But it also says trunk contents. I don't know what to think about what this stuff could be because this is the defense list. So if it was the state presenting trunk contents and goggles, then I would assume one thing. But knowing that this is coming from the defense, whose goggles is this? Because if it was Bryan's, that doesn't really make a lot of sense for them being the ones to submit this. Something else I'm really curious about is why they have weather reports for 12/14 and 12/15 of 2022. 12/15, 2022 is the date of the Indiana traffic stops, and he wasn't even in the area on 12/14 and 12/15, 2022. So I don't know why the defense has this in here. That doesn't make a lot of sense to me either. Then they want to show all of the press releases and their updates. They were planning on submitting every single one of them, as you can see here. That's all it goes to. And it stops on the 1/3/23 press release. The following items have been disclosed as exhibits by the defense. Again, the defense intends to use these as demonstrative aids in trial. Although typically not discoverable, the defense is disclosing these items in discovery as a courtesy and in an abundance of caution. Well, considering the fact that what's-his-face, Hippler said he wanted it, how did he put it? If you're going to come up here and tell me about DNA and you're going to do a PowerPoint and you're going to do like a small science lesson, then I need to be able to see that in the information that you're submitting in order to be approved as an expert here. So I don't see how DNA transfer information, stuff from CyRay as a PowerPoint. I don't see how stuff from Barbara Wolf, all the stuff that actually has to do with fingerprinting and methodology and DNA transfer. How could any of this not be considered discoverable if it's part of expert witness testimony? That sounds stupid. That sounds dumb and like the opposite of what it should be. So then we have connections demonstrative exhibit. I don't know what this is. I don't know what this is because there's no connections between Bryan Kohberger and the victims or the house or anybody that the victims know. There's no connections, and this is a defense exhibit. So is this just like showing all the people that the victims knew that could have like been around, or what is this? I don't know what this is. Then we have Ballard with a PowerPoint in DNA transfer in the University of Idaho case, which would be this one. Ballard again, PowerPoint understanding DNA transfer. Then a PowerPoint from Shuttler. Then a PowerPoint taking inked fingerprints, information on inked fingerprints from Bright Birnbaum PowerPoint. Bright Birnbaum PowerPoint again for ACE methodology. Birnbaum again, comparison to exclude, but I don't know what this is for. It's not enough of a title for me. Barbara Wolf and CyRay both had PowerPoints. So how would anything from CyRay be considered normally not discoverable? That's pretty stupid. Okay. The following items have previously been disclosed as exhibits by the defense. Although these items are summaries of discovery previously disclosed by the state, the defense is disclosing these items in discovery as a courtesy and an abundance of caution. And see how it says Nodal video, and Matthew Nodal is on the defense list. I don't know if this is like a Faro scanning person or what this is. I'm gonna have to go back into the documents, but I don't remember which document this guy was mentioned in. I just know we've read the name before. I just can't remember which one. It had to have been recently. Okay, a video from this Nodal person of the entire house, the third floor again, and then the third floor slowed down, which is interesting. Down one. What does that mean? Down one. I think it was supposed to say Dylan one because it goes 2, 3, and 4. And we know that we've had at least, well, there was one interview with MPD, and then we have 11/17 and then 12/30. But then we also know that we have a report from the Idaho State Police, and we know damn well she talked to the freaking feds. So there's way more than just the couple of interviews that we've been told exist, because we haven't gotten to see anything, including any sort of like supplemental list of what's to come from the feds. So there's that. Xana exit 2. What does that mean? Exit 2. I don't understand that. Hallway look around model. Hallway look around no model. Exit Xana. What does that mean? Bethany, Dylan, Ethan, Kaylee, Madison, Xana, timeline. Would it have been a timeline for Xana and Ethan? Because y'all can't even tell us what time they got home. You can't. Slovinsky with 11, 13, 22 handoffs. I'm guessing that's like phone stuff. Because we've heard that term when it comes to cell phone towers. Then we have BK call and VTM. I don't know what this means. BK call for what? Does it stand for vitamin? Remember they found supplements in his car? Vegan supplements? Is that what this is? Why are we using this? What is this? BK call to what? His parents that morning? I really wish that they had better titles here because this doesn't really give us any information. This one does. The geofence report. We know what the frick that is. Then we have the July 9th pool party information. It's interesting that the defense is the one putting that in here. And then 3 days later, on July 12th, a mountain hike. See, okay, so we were told from the DJ with the long black hair from the pool party that he saw Bryan Kohberger hiking later on after the party and that he didn't recognize him at first and that Bryan seemed like a little bit too overly excited to like see him. Was it just like 3 days later? Was it this time? Was it the July 12th mountain hike that he ran into that guy? Because he didn't give us like a time frame. So I'm wondering if it was just like a few days later. Because remember, that's also what he was talking to that one girl about where she handed him her phone and he put his number in her phone and she instantly texted him. It was about hiking. So I'm wondering if that was when he saw him. Slovinsky cast final report analysis. So this again is the defense. So this is like somebody taking the cast report and doing their own report on it, I guess. The AT&T breakdown. Okay, yes, previously disclosed by the state. Well, I would hope that they would have the same information. That was what we're like hoping to see, you know. Excel Wi-Fi status, Kohberger phone jury version, condensed version of D1048. So not everything. Phone jury version. Does this mean grand jury version? Excel Wi-Fi status, Kohberger phone full. Okay, that's like everything then. Okay. This says the following items have previously been disclosed as exhibits by the defense. The defense intends to use these in the mitigation phase should the case proceed to a phase 2 trial. So if the trial would have commenced and if he would have been found guilty and it was going to where the DP and those other things were all going to be considered, this is the information that they would have submitted. A photo from Pleasant Valley District Office, a photo from the Pleasant Valley Security Office, a photo of the exterior of 1119 Lambsden, 2 photos from DeSales, maternal genogram, paternal genogram, car accident reports. Car accident reports. Were they going to like try to say if he was found guilty that he was in a car accident and he hit his head and that's like what made him a killer? Is that what they were going to do with this? Why are we talking about car accidents? Do I have his Carfax still saved here or did I print it and put it in a folder? I don't remember there being anything on the Carfax about the car ever being in any sort of accident. I just don't remember. I don't know if it's on my computer still or if I put it on the USB. I try to put everything on the USB and get it off my computer because the files can be real big. I don't think it's in here. Wait, nope, that's not it. No. It's on a USB. I don't have it on here anymore. I don't remember it saying anything. I don't remember it saying anything. So make sure I don't have it on here. Search everywhere. Carfax. No, it's on a USB. Yeah, I don't know why they're putting this in here because he didn't have one on his Carfax as far as I can remember. And again, that car was given to him by his mom. So I'm just curious as to what this is. Pennsylvania education writing reports, Bryan Kohberger report cards, and then a statement from the Kohberger family dated all the way back January 1st, 2023. Remember, they were like, we support him. This is not okay. They got the wrong guy. Like, it's always been that from the very beginning. We've gone over what the family has had to say. Okay, that looks to be it when it comes to what I had planned to talk about for the defense documents. They didn't have anything else come out today. Then again, it's Saturday, but sometimes whenever they load stuff into the page, it'll pop up later on. There's still little documents we have to go over. So we'll be doing that. We're just going to continue going over them. I don't know if I'm going to do 2 lives tomorrow because it's Sunday. So we'll probably do 1 live tomorrow. I still have like other things I'm going to be posting, but we'll probably just do the 1 live tomorrow. And then I'll schedule lives throughout the week to finish going through the rest of the documents. And we still have body cams and stuff to go over. Oh my God. Did you guys see? The stupidity? Oh my God. All right. Well, look at this shit. Let me show y'all something. I saw this on Twitter. I don't know if it's her video or if she got it from somebody else. I don't know. I'm guessing she got it herself. But Bad Mom Bree is a channel here on YouTube that has some of the body cam stuff. And Blaker interviewed Josie and didn't turn on the freaking audio, bro. It's just silent the whole time. It's playing. He didn't turn on the audio when we walked in. So there's nothing to support what's being said here by Josie. This is one of the ones that walked over with Hunter Johnson and Emily Allant that morning. Like, what? Just so wild. Here, I'm going to give y'all this channel too, in case there's some stuff over there that she has that you guys haven't seen yet. I know that the Connor channel has posted a couple more things. Let's see what else she's got on here. Yeah, like body cams. Stupid Howie. Dumb old Howie. Ugh. Dumb old Howie. Okay. Yeah, it's not surprising, but it still like makes me so mad because how can you be this unprofessional? Just how? How can you be this unprofessional? Exactly. Exactly. Like, what? Oh yeah, the sandwich tweaker. The tweaker from this morning that brought SWAT to my neighborhood was just a schizophrenic guy that was fed up with his family, so he went on the roof. The only real drama was caused by the cops. So home dude just wanted to make a sandwich and go on the roof and be left the frick alone, and the cops showed up acting crazy. Poor guy. I mean, that sucks. That sucks. That's crazy as shit. No, we see you. What are you talking about? It might be your internet. It might be your internet not being able to catch up with the speed that the chat's going. I can see you. Yeah, I was really looking forward to what she had to say too, because she's a little weird. I don't know if y'all seen, and I mentioned this before, and Bad Mom Bree has it on her Twitter page. There's pictures of like Josie and the Linden dude that was with her that morning and at the house that morning. They weren't officially together at that point. They were just sort of like in the talking phase. They didn't become official until afterwards. And she posted something. I don't know what platform it was on, but they have screenshots of it on Twitter. And it's like, my friend died and he realized he loved me, so now we're together. Who just like writes that kind of shit on a photo where you're all smiles and cuddled up with your dude? Like, it's just odd. It's just odd. It's just real freaking odd. But yeah, this doesn't surprise me. It's odd. Thank you, Holly. Thank you for being I can't even talk. Thank you for being in here. Yeah, just wanted some peace on his roof with a sandwich. Isn't that crazy? I'm gonna like look up that story now and be like, you poor dude. You poor guy. He just wanted a sandwich and some peace and quiet. That's crazy. Yeah. Just go look up Bad Mom Brie on Twitter. It's spelled the same way as the channel has it, or she might even have a link for her Twitter page. But yeah, it's on there. She shares it a lot because it's so just like outlandish. Like, how do you just like put that on your post and think that that's not gonna like rub people wrong? My friends were all murdered, and so he realized he loved me. I'm sorry. You probably could have kept that inside thought inside and just be like, hey, we're together now. How cute are we? You didn't need all that extra stuff. We didn't need all the extra stuff. We just didn't do it. We just didn't. Okay. I'm going to go ahead and get off of here because I promised that I would play some games tonight. I'm sure Don's going to try to cheat, especially now that he's feeling better. I'm sure his cheating is up to par. So this will be fun. Did y'all know there was a Arizona tea game? I think I mentioned this to you guys before. I found it at Kroger. It was on sale for like $2.70, and I bought it, and it's a big old can, and it has little bitty cans of tea, and you have to play cards like Uno, but you have to like add it up. Well, not like Uno then. So you play cards, and you have to add up to 99 cents, and you can like take it away, but you have to like add it up. The first one to get to 99 cents without going over wins. It's like all about beating inflation. It's kind of cool. It's kind of cool. Yeah, Arizona tea game. Arizona tea game. It was at Kroger. Let me see if I can find a picture of it on here. Arizona tea game. Arizona tea is doing all kind of crazy stuff. Have you watched them on Twitter? They do with some cray stuff. They're doing all kind of crazy stuff. Yeah, it's right here. Share the screen. No, wrong button. Wrong button. Yeah, see? Comes with cards. Little bitty teas. Oh, wait, where's it going? Where is it going? To Target. Well, I got mine for less than $3. I got mine for less than $3 at Kroger. But yeah, it's fun. And Don tries to cheat all the time. That's fine. That's fine. All right, you guys. Again, I don't know what time we're going to go live. We're definitely going to do a live tomorrow. I just don't know what time. It's not supposed to. It's not supposed to. They have their price still set at 99 cents, but they can't stop people from selling it for higher. Like if I go down to the gas station right now, it's like $2.29, bro. $2.29. But Kroger puts them on sale for like 89 cents a lot. Sometimes 79 cents. They can't stop people from selling it for higher, which you think that it would be like in a contract that you can't sell this for more than 99 cents. But, you know, people are greedy. People are super greedy. Yeah, no, I'm going to put it up in the morning because I'm going to figure out like what I want to go over tomorrow and get it all scheduled out. It'll be in the evening probably because I know that there's a lot of stuff that people do on Sundays. And I know apparently football's a thing. Football's a thing that I have to pay attention to. So there's that. So I'll pay attention. We'll do it later on in the evening as to not disturb the football people, which is fine. That's not a big deal. Thank you so much for the members that showed up. I know that some of you guys became members from gifted memberships that were from the previous live that sort of like rolled over. So congratulations on the memberships. Don't forget our members only live for October is going to be October 27th. I'll get something out for that soon here too. But I'm going to go ahead and get off of here and go start playing this game. See how many little teas I can collect myself. But again, thank you so much for being here. I'm going to go ahead and roll this out. Please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. Okay, you guys. See y'all.